This will ensure that we can just keep this discussion going, but keep it going in a more meaningful fashion. This is the amendment that was just withdrawn by the gentleman from Colorado, which I guess was introduced on behalf of the gentlelady from Illinois. Again, I'm sorry she isn't here to be able to debate her own amendment. I understand from the chairman she has members of her family which are quite ill. Again, as I look at the underlying Watt-Moore amendment, and certainly I applaud these two gentlemen for the serious work that has been done on this particular matter, but I still have a number of concerns and believe that the Bean language is far more superior. I believe that the Watt-Moore amendment, number one, would significantly narrow the current standards for preemption that ensures that the OCC and the OTS actions could possibly be litigated for quite some time. I believe this means that the OCC will have to undertake a separate regulatory process for each state law or local ordinance, creating a greater burden on our interstate banking system. The amendment denies the OCC and the OTS the deference that is granted to every other federal agency under the Chevron doctrine, and the amendment applies the preemption restrictions to all state laws, which, as we just had a discussion over the safety and soundness issue, I believe that this amendment means that federal and safety and soundness regulations could still be overridden by state laws. My reading of the amendment further is that the amendment would empower states' attorney generals to go, frankly, beyond the Cuomo case, which we have discussed. I believe that to be bad policy. Clearly, I don't like the underlying legislation, but I do believe and hope that those who are trying to work on some type of compromise language would think about the burden to our already overburdened banking system, that going from essentially one standard to 51 standards would have. The Bean language, certainly left to my own devices, is not something I would necessarily enact into current law, but I would hope that members would at least give it serious consideration, and I look forward to the committee having an opportunity to vote on it. As we know, it would preserve the current law, but leaves intact the provisions of the discussion draft that permit visitorial powers for the state AGs. Again, it's perhaps not the perfect language, but I hope it would represent more common ground among those who are concerned with the extraordinary burden that could be placed on the system, I think threatening potentially, again, safety and soundness of our system. And the full impact of a law that still, at the end of the day, has the ability, whether the chairman believes the director would exercise it or not, has the ability, has the legal authority to ban products for what many estimate to be for as far-reaching as 10 to 15% of our economy. And I would be very, very hesitant that once we have such a draconian law put in place, that we could have 51 different versions of this draconian law, making it draconian on steroids. So again, for those who are looking for some common ground, I would hope they'd give very serious attention to the Bean amendment, and I'm happy to re-offer it for an actual vote. Mr. Chairman, I yield back the balance of my time.